Welcome to the fourth podcast. Hi, I'm Gil Kennedy, President and CEO of Har-co Credit Union. Today we're going to provide you with information around the law. Things such as estates, advance directives, powers of attorneys are extremely important. I talk to many of my friends and I constantly remind them of the necessity to be able to have those documents and keep those documents in safekeeping. I'm honored to be able to present to you Mr. Chuck Wellington. Chuck is actually a board member here at Har-co Credit Union, but also a general practicing attorney in the town of Bel Air. In fact, his office is at 101 Thomas Street. With that, I hope you're able to use the information that we provide you with, and I hope that you share it with your friends.
Chuck, thank you for taking the time today to talk through the legal side of this crazy world we live in. By way of background, share a little bit about how you got to your office here in Bel Air and your educational background and your time as a resident here in Harford County.
Sure. Almost a lifelong resident. I moved to Joppatown when I was 13 years old. Grew up in Joppatown pretty much. Went to Joppatown High School, graduated there in 1980, and then went on to Loyola College and University of Maryland School of Law. Graduated there in 1987. While I was in law school, I clerked for a small firm in Bel Air. I clerked for a large firm and medium-sized firms in Baltimore and Towson. And I really loved working in Bel Air. I liked the small town feel. And I had the opportunity to go either way. Could have made a lot more money going to Baltimore or Towson. But I made a conscious decision to come back to Bel Air and be a bigger fish in a smaller pond, so to speak.
That's great. You're in the general practice of law, right? What does that really mean?
Well, it's a general practice. I do a lot of the things that most normal people need, like wills and estate planning, unfortunately divorces and custody cases, child support, guardianships, some things that are more positive and rewarding, like buying and selling businesses or adoptions. I try to stay away from criminal law and personal injury. I have an office mate who does that type of work, and so I refer that type of stuff to him, and he refers the other stuff to me, and we're not stepping on each other's toes.
You said a really important thing, and that was estate planning. What is estate planning, Chuck? And what does it really mean? What does it include?
Sure. Well, of course, with COVID and all that, it kind of accentuates the importance of doing the estate planning. And basically, estate planning in a nutshell is taking steps to try to make things easier on your family members in the event that you die or become disabled. And, death is a fact of life. Disability, whether it's permanent or temporary, is a fact of life for a large percentage of people. And so by doing your estate planning, you're taking steps to control your destiny, so to speak. You're going to control who gets your assets upon your death. You're going to control who gets to manage your estate, who can manage your assets while you're alive if you become disabled, and who you want to make the decisions for you with regard to health care if you can't make those decisions for yourself. So typically, estate planning is going to include, at a minimum, a will, or a last will and testament. It's going to include a financial power of attorney, a healthcare power of attorney, and possibly a living will, depending on what somebody's wishes are, what their beliefs are with regard to having artificial life support near the end of life. Some people are very adamant they don't want to be kept alive artificially. Some people do want to be kept alive artificially, and so it's going to depend on their ethical beliefs, their moral beliefs, their religious beliefs certainly, and just their own life experiences, what they've seen their family members and friends go through at their or near the end of their lives. Sometimes estate planning is going to include one or more types of trusts, either for children or grandchildren. There's different types of trusts. Also, estate planning should be coordinated with your insurance planning, your financial planning. All those things kind of go together.
A lot of great things were in that part of the conversation. What exactly is a will?
Okay, so a will is a document that you sign that says who you want to get your assets upon your death, who you want to manage your assets upon your death, or who you want to manage the probate process. And what that basically means is somebody's going to gather up your assets, make sure your bills get paid off, make sure the assets get distributed to the people that you say you want the assets to go to in your will. So those are some of the more common reasons for having a will. You can also provide for charities of your choice in the will. You can set up trusts for minor children or grandchildren to make sure that assets don't go to them before they're ready to take on that kind of responsibility.
I know a lot of people put this effort off. What if I don't have a will?
Sure. So if you don't have a will, the state of Maryland kind of makes a will for you. And so there's a statute in Maryland, as there is in every state, and each state's a little bit different, but it's called the intestacy statute. And what that means is that if you don't have a will, that statute's going to say who gets your assets upon your death. It's typically similar to what most people do in their wills, but oftentimes it's very different as well. And so if you want to trust the state statute to say who gets your assets, maybe you don't want a will. But if you want to control where your assets go, then you need the will. Also, if you don't have a will, a judge is going to have to pick somebody to be your personal representative or executor to probate your will. And that might be the person that you had in mind. It might not be the person that you had in mind. If you don't have a will and you have minor children, they're going to get their inheritance when they turn 18. Now, I don't know what you were like when you were 18. I remember what I was like when I was 18. I was pretty responsible, but I was still not ready to manage any kind of significant money. Some people, they're more able to manage those funds when they're 21, 22, graduate from college perhaps. Sometimes they'll pick an age even later than 21 or 22, maybe 25, 30. You're only limited by your imagination as far as how that's going to be set up.
Great. And there was another term that you shared called power of attorney. What exactly is power of attorney?
Sure. So a power of attorney, and there's different types, but basically when you sign a power of attorney, you're giving someone else the authority to make decisions and sign documents for you. So two of the more common types of powers of attorney that I mentioned earlier would be a financial power of attorney, where you're naming somebody who's going to have the authority to deal with your finances. They can sign checks for you and pay your bills, do things like vote your stock, sign your tax returns, anything of a financial or documentary nature, you're giving them the authority to do that for you. For a healthcare power of attorney, you're giving someone the power, the authority to make your healthcare decisions. So if you're lying in a hospital bed unconscious or mentally incompetent and you need surgery, the doctor needs to know who's got the authority to make the decision for you. So those are the two most common types of powers of attorney. There are others, but those are the two that we normally do when we do the estate planning. With the powers of attorney, it's important that you choose somebody that you know you can trust. And you also want to name a backup person if there's somebody that you feel safe in naming as a backup, because something might happen to your first named power of attorney before something happens to you. And if something does happen like that, you don't want to have to run back to your attorney, right away. You want to be able to take your time with something like that. It's also important to specify in the power of attorney, when is it going to take effect? Is it going to take effect when you sign it? Or is it going to be what's called a springing power of attorney, which means it becomes effective at some future date or upon some future event? And so that future event typically would be upon becoming disabled or mentally incompetent. My preference, and I think the preference of most attorneys, is to make the power of attorney effective when it's signed, if you feel safe in doing that. That way it's clear, it's in effect. If you have the springing power, then you need to define, well, when does this become effective? And typically you would put in your document, this becomes effective when I'm declared to be disabled or unable to make my own decisions. Well, what does that mean? Typically it means, well, I have to be examined by 2 doctors, and they have to agree that I need somebody to make decisions for me. Well, at that point in time, when you need somebody to be able to act pursuant to the power of attorney, you don't necessarily have the time to run out and schedule 2 doctors' examinations and then hope that they agree that yes, you are disabled and you do need somebody to make your decisions. So important to name somebody that you trust, a backup for that person, and then specify when does the power of attorney become effective.
You mentioned earlier that if you don't have a will, the decision actually passes to the state. Does the same thing happen with a power of attorney?
Well, if you don't have a power of attorney, in the healthcare setting, it may not be a big deal. In the healthcare setting, the doctor may say to the family members, okay, this person's unconscious, they need surgery or they need this medication. Do we have your permission to do that? However, sometimes in the healthcare setting, that's not going to be good enough, especially if there's a disagreement amongst the family members. What if the spouse doesn't agree with the adult children or the in-laws? You hear about those kind of situations in the news occasionally. In regards to the financial power of attorney, if you don't have a financial power of attorney, the bank is not going to let the spouse or the adult child or other family member make those types of decisions or sign their checks to pay their bills. The bank and sometimes the healthcare provider are going to require that the family members of the disabled person file a guardianship action. Now, a guardianship action typically involves filing a complaint in the circuit court. The court will appoint, and typically that's going to be done through an attorney. Most people aren't going to handle that on their own. They're going to hire an attorney. So that's attorney number 1. Once the complaint is filed with the court, the judge is going to appoint an attorney to represent the alleged disabled person. That's attorney number 2. Both those attorneys are going to want to get paid. The disabled person has to be examined by 2 physicians. We're back to that 2 physician scenario. So that means scheduling 2 doctors' examinations. Have to keep your fingers crossed that the doctors agree that this person is disabled. And sometimes it's not always clear. Somebody that's in the early stages of dementia or Alzheimer's may not be competent in the morning, but they're competent in the afternoon or vice versa. And so what that doctor is going to conclude may depend on what time of day the appointment is scheduled. So you file all that with the court, pay the attorneys, pay the filing fees, and then the attorney that's appointed to represent the disabled person does an interview of the disabled person if they can. They're going to review their medical records, maybe talk to their doctor. They're going to issue a report to the court, and then the court's going to schedule a hearing. And then the judge has to decide, does this person need a guardian? If so, who's the most appropriate person to be the guardian? Sometimes it's going to be clear. If there's a spouse, the spouse is probably going to get the nod to be the guardian. But again, you could have a disagreement within the family who should be the guardian, and especially if it's a second family scenario. Maybe somebody's gotten divorced, and now you've got their new spouse fighting with the children from the first marriage over who should be the guardian. Or you may have multiple adult children all arguing about who should be the guardian. One of my very first cases when I was still clerking for a law firm down in Baltimore was a situation where he had 2 daughters, adult daughters, who wanted to be mom's guardian, and had like a 3-day trial. And at the end of the trial, basically the judge concluded that they both wanted mom's money. And so what the judge did was he appointed them jointly as guardian of her person. They could make decisions regarding where she was going to reside and what kind of medical care she was going to get. But the judge appointed a neutral person, another attorney, somebody else is going to have to get paid, to be able to handle mom's finances. And so the judge got the clue pretty quickly. For these daughters, it's not really about mom's care, it's about mom's money. And so he took the control away from them.
We mentioned earlier having a will. There's another term called a living will. What exactly is a living will?
Right, so back when I graduated from law school back in the late 1980s is when living wills first really started becoming popular. And so Maryland and other states enacted statutes that said people have the right to control their destiny. They have the right to say whether they want to be kept alive through artificial means or not. And so These statutes provide that if you sign this document, which is commonly called a living will, you can specify what happens if you have a terminal illness. Do you want to be kept alive artificially? If your death is imminent, if it's going to happen any time now, do you want to be hooked up to machines that are going to breathe for you, pump blood for you, give you food and water through tubes and such? Or if you're permanently unconscious or in a persistent vegetative state, and again, we see these stories in the news occasionally, and so the living will is going to say, do you want to be kept alive artificially or don't you want to be kept alive artificially? And again, just like with the healthcare power of attorney, the doctor or the hospital may work with that family even if there isn't a living will. But it's best not to take that chance, because I've seen situations where the hospital said, hey, if they don't have a living will, we're going to keep them alive as long as we can because that's what doctors and hospitals are supposed to do. The risk there is that the doctor and the hospital are not going to work with the family members, and then you're back to running into court. Running into court's a relative term there, because nothing happens very quickly in court usually. And you're going to try to convince a judge to sign an order that directs that the life support be removed, if you can convince the judge that that's what the patient would have wanted. So for a very inexpensive cost, a living will is a lot better than taking the chance of having to go to court, or maybe even having to try to transfer that patient to another facility where they'll work with the family just because the first hospital won't.
It sounds like all these instruments are important. They're things that we should all have.
Right, and so that's kind of the bottom line is it's about control. It's you controlling your destiny, and it's about making things easier on your family, taking the stress and strain away. Because, going back to that living will situation. Now, the living will, that's the common term for it, but it's not about living, it's about dying. And it's not a will, it's not a last will and testament that we talked about earlier. But for some reason, that was the terminology that was used, and it stuck. I call my document a declaration. Some people call it a dying declaration. Some people call it an advance directive, which would be a combination of a healthcare power of attorney and a living will. Some attorneys combine those two together. I keep them separate. I think the majority of attorneys do, because they deal with two different situations. The healthcare power of attorney, you're naming somebody else to be able to make healthcare decisions. You're delegating authority, life-prolonging decisions, hopefully. Whereas with the living will, that's you making the decision for yourself. You're not delegating that authority. Who would want that responsibility? And so with the living will, you're taking the burden off the family, possibly being asked by the doctor, okay, did this patient want to be kept alive artificially? Do you want us to pull the plug, so to speak? Imagine the burden on the family being asked to make that decision. Are they going to feel guilty? Did we pull the plug too soon? Did we not pull it soon enough? Did we keep the patient alive in pain when there was no reasonable hope of any kind of meaningful recovery?
And the living will, that advance directive allows you to make the decision for them ahead of time or before the event.
Right. So by having the living will and the healthcare power of attorney, you're designating, with regard to the healthcare power of attorney, who's got the authority to make the decision, so there's not going to be any dispute about that. And with regard to the living will, it's you making the decision for yourself that you don't want to be kept alive artificially if you're terminal or permanently unconscious, and there's no meaningful expectation of getting any better.
So let's switch gears a little bit, Chuck, and let's talk about the after the death. There's this term called trust, right? A trust. What exactly is that? Right.
So a trust can either be a living trust, meaning that it comes into existence while you're still alive, or it can be a testamentary trust, which means it becomes effective upon your death. And so typically the testamentary trust is based on language that's contained in your will. So the most common, perhaps, type of trust is what I mentioned earlier, a trust for children or grandchildren. Typically it's going to be children, where you have a couple who comes in and they have minor children, and they want to make sure that the children aren't going to get the assets when they turn 18. and they want somebody who's trustworthy, a trustee, to manage those funds for the children until they reach a responsible age. And so if I'm a parent and I die, my spouse, the other parent has already died, I want to make sure that the person that I've named as trustee is going to manage those funds for the benefit of my children. Typically, there's going to be language in the document that says that even before they reach those termination ages, money can be spent for their health, education, support, and welfare, basic types of living expenses. And then it'll say, okay, they get it when they're 22 or 25 or half 22, half at 25. And in the meantime, you've got somebody trustworthy, perhaps a family member, perhaps a bank trust department that's going to manage those funds for them. Now, there's other types of trusts. There's something called a revocable living trust. I'm not a big proponent of those, and we could spend another whole session just talking about the pros and cons of that. There's life insurance trust, there's marital trust, but basically the concept of trust is you're creating kind of this this third person, this fictional party, to hold and manage the funds for the benefit of perhaps yourself and more often for somebody else. And it'll specify what the money can be used for, when it can be distributed, when the trust is going to terminate.
How about title as it relates to assets? Let's say I have a truck and I have to get a title for the truck. Is it important whether I, at the outset, give that to my son or my daughter?
It does matter, and a mistake a lot of people make is not taking that into consideration when they do their will. And so they may come in and they say, I've got 3 children and I want everything to go equally to the 3 of them. What they don't keep in mind is how you title an asset controls or takes priority over what it says in your will. So if you've got that truck and you put your oldest son on the title to the truck with you, thinking, well, that'll make things easier when they have to go through probate. They don't have to, maybe go through probate. And they're thinking, right, well, that son, he'll share the value of that truck with his 2 siblings. And that may in fact happen, but sometimes it doesn't happen. And so if you want to make sure everything goes equally, you either need to make sure everything's titled equally, because that's going to take priority, or make sure that you provide for the equal distribution in your will.
And now some assets that we all have another category called beneficiaries. Like in my business, we have life insurance where we name beneficiaries. Is it important to bring that into the equation?
Yeah, absolutely. And just like title takes priority over what it says in your will, a named beneficiary takes priority over what it says in your will. So when you're signing a beneficiary designation form, that's a contract between you and your employer or an annuity company. And that contract takes priority, and that contract's going to control and designate who's going to get those assets. So again, if you want your assets to go to your 3 children equally, but you only name one of them as beneficiary, well, that one of them that's the beneficiary is going to get those assets. So what I do when I'm talking to people about estate planning is I make sure that we explore, okay, well, do you have assets that have a named beneficiary? If you do, let's talk about what that means and how it may be better to not have a named beneficiary and just let those assets go into your estate and pass pursuant to your will.
Is there anything I should worry about as far as taxes in death? I think they're even called death taxes.
Yeah, and they are death taxes. The good news is, well, the bad news is there are death taxes. Right? And the good news is most people don't need to be worried about it. There's a federal estate tax, which is a pretty significant tax if it applies. The tax rate can be as high as 50% or so. But the good news is it only applies to assets over, the current exemption amount is around $11.4 million. So if your assets are under $11.4 million, you don't need to worry about the federal estate tax. There's also a Maryland estate tax. And that's a tax that's a 16% tax rate, which is still pretty significant. But again, there's an exemption amount. Right now, the exemption amount is around $5 million or so. And so if your assets are under $5 million, you don't need to be worried about that tax as well. And then there's a third death tax. If two aren't bad enough, there's a third one. And the third one is the Maryland inheritance tax. And that's a tax of 10%. There is no exemption amount, but there are exempt people who can inherit from you and not be subject to that tax. So the tax does not apply to anything that you leave to a charity or to an immediate family member like a spouse, a child, a grandchild, brother, sister, parent. They're all going to be exempt from that Maryland inheritance tax. But if you leave assets to a more distant relative like a nephew or a niece or your next door neighbor or your friend down the street, there's going to be a 10% tax on that inheritance.
Great. And one last and important question. A lot of people don't move ahead and get these documents done because they fear the cost. Is this an expensive thing to set up your estate plan, and this process of creating the first steps in getting there?
The basic package of documents, the will, the financial power of attorney, the healthcare power of attorney, the living will, that's what most people do when they do their estate tax or their estate planning. That package of documents for a single person, I typically charge around $250 to $300 or so. If they want a trust for minor children, it's going to be slightly more. For a husband and wife, typically the package is going to be somewhere between $350 and $450, depending on whether they have minor children and want the trust for the minor children. It's what I call a loss leader in the business world. Sometimes you sell things for less than what it's really worth because you're hoping to get that relationship with the customer or the client in this situation, and you hope that they come back to you for other work that you can charge them your regular hourly rate for. And so a lot of attorneys are going to do this type of work in effect at a loss. They're not making their normal hourly rates when they do this type of work. Now, there are attorneys out there who are going to charge a lot more. I mentioned revocable living trust. Again, I don't want to go into it right now, but some attorneys are big proponents of them, and sometimes for legitimate reasons. But if you're going to do that type of estate planning, you can expect to spend a lot more money because it involves not just the document itself, which is rather complex, but also changing the title or transferring title to assets to put them into the trust to really try to take full advantage of the positive things that can happen as a result of the trust. So typically for most people it's going to be less than $500 for the basic set of estate planning documents.
It seems like a very reasonable amount of money to pay for this estate plan, and you said it's a loss leader for the attorney. And so the attorney's not making money in a lot of respects on this, but looking to build a relationship. But it seems to be a very valuable set of documents to have, and right now so many people don't. Especially during a time like COVID. Any last comments you would like to make in relation to kind of getting this process started and why it's so important?
Right. So, yeah, it's a good point, and I've had several clients come in who, specifically because of COVID, have said, hey, we want to get our documents in order, we want to make things easier on our families. And so that's one part of the practice that stayed pretty steady throughout this time of being kind of closed up from a business standpoint, and stay-at-home orders and all that type of thing. But it's a good idea any time in life. You don't want to wait till it's too late. You don't want to wait till you're incompetent or you've passed away and then you leave a mess for your family to try to deal with. And I've had a number of those types of situations where somebody calls up and says, okay, my mother or my father, they're elderly, they don't have a will, they don't have powers of attorney, they don't have a living will, what can we do? And one of my first questions is, are they competent? Are they going to understand what it is that they're signing? Are they going to understand the legal ramifications of signing a will or a power of attorney? And if there's any hesitancy there, I'm like, I think we might have a problem here. And sometimes I'll say, well, if it's in doubt, you need to go get a doctor to examine them and issue a report saying whether they're competent to sign documents or not. Because it's not going to do anybody any good to have somebody sign the documents and then have the documents be challenged, questioning whether that person was competent to sign them or not.
Very good. Chuck, go ahead.
Yeah, one of the things that I forgot to mention earlier with regard to why it's important to have a will is, again, with the situation where there are minor children involved, is naming a guardian or guardians for your children. And by having the will, when you have the minor children, it lets you pick who's going to raise your children till they reach age 18, rather than having some judge pick who that person's going to be. And you can picture the situation where maybe a husband and wife die in a car accident or plane accident, and there's minor children involved, and perhaps the husband and wife, they knew exactly who they would want to raise their children. But grandparents on both sides come in, and now they're fighting over who's going to be the guardian for these children. And so by having the will, it allows the parents to make the decision about who they feel is going to be best to fill that role.
Yes, it's a really important thing. My wife and I were put in a position at a very young age where we were asked to be the guardians, to take care of children upon death of some friends. Had they died, they didn't, thank goodness, and instead of what would have been the grandparents. So based on their age, they thought it would be more valuable to have a younger family take care of their children upon their death. Luckily, we never had to go to that outcome, but it is a really important thing to consider at a young age.
And that equally applies to a lot of what this is here with estate planning. It's kind of like insurance. Some of this is stuff that you hope you never need. A financial power of attorney, a healthcare power of attorney, if you are mentally competent till the moment of your death, you never need the power of attorney. If you are relatively healthy until the moment of your death, if you drop dead of a heart attack, for example, you may never need the living will. So some of those documents, it's like paying for insurance. You hope you don't need them, but if you do end up needing them, they're worth their weight in gold. With the will, though, that's something everybody needs. Everybody's going to die. Can't change that. That's just a fact of life.
Very good, Chuck. Thank you very much for your time. It's been great and very informative to learn about the law, and appreciate your time today. Thanks again.
My pleasure.